And today I'll be speaking about transfer pricing and focusing mainly on the Italian perspective. So, okay, we can see the slides in a second. Just in anticipation, while we wait for the slides to come, I will briefly focus on also on Pillar 2. I will just briefly introduce it as a comparison to the system outlined by transfer pricing, which will be our Pillar 2 system will later be explained more widely and deeply by my colleagues. Okay. Perfect. So, to introduce our theme, we can have a look at the Italian legal framework we are going to refer to. So we have the main principle, piece legal framework, which is Article 110, Paragraph 7 of the TUIR, the Italian Tax Code, the main regulatory reference for income taxation in our country. Also, very briefly, legislative decree number 50 of 2017, which comes to our attention because it represented the Italian legislators' alignment with the OECD guidelines. Again, the ministerial decree of 14th of May 2018, which contains the actual guidelines the Italian legislature, the Italian tax authority should base its operation on. And this ministerial decree was introduced following the legislation decree number 50 of 2017 I just cited. Finally, Article 31 Quater of Presidential Decree number 600 of 1973, which comes to our attention because it regulates the instruments which can be used to solve double taxation issues in Italy. And finally, of course, Article 9 of the OECD model, which represents the main source where we see the arm's length principle, as anticipated by my French colleagues. So, again, here I've already been anticipated, so I won't spend too much time speaking about definitions, but just as a reference to the Italian perspective, I would focus mainly on Article 110, Paragraph 7, again, of the Italian Tax Code, which contains the definition, the Italian definitions. The next slide shows actually the article. Okay, perfect. We see that the components of income arising from transactions are determined with reference to the conditions and prices that would have been agreed between independent entities operating under conditions of free market, so free competition, and with comparable circumstances. We see that this version of the article, I will say in a moment, we had a previous version of this same article, is a clear reference to the principle contained in Article 9 of the OECD model, as completed by the OECD guidelines, which play a fundamental role in actually outlining the meaning of the principle of arm's length principle, of the arm's length principle. Again, if I can ask to go back to the slide, please. Thank you very much. The first, the one before. Okay. Very quickly, because my French colleagues already have introduced the topic, I'd like to again suggest the aim, the objective of these adjustments. It is clear that when we speak about associated enterprises, so controlled transactions, we refer to financial or commercial operations that intercore between associated enterprises. The Italian legislature offered a definition of associated enterprises, which is contained again in Article 110. We can outline this definition. I didn't put it in the slide, but I can briefly speak about it. it consists of transactions concluded between an Italian enterprise and a foreign company. So a company not resident in the state, in the territory of the state, of the Italian state. This is peculiarity, probably, of the Italian system, which wants on the Italian side an enterprise and not a company, so it's very specific. Whereas on the foreign side, it refers to companies. Moving on, okay, next, perfect. How do we determine, no, the one before, please. Okay, perfect. How do we determine transfer price? Well, I'm referring here to the reference value, which is useful to determine to determine intragroup prices. So, as I previously mentioned, there was an original version of Article 110 of the Italian Tax Code, which referred to the normal value of the goods or services, and again, it had contained a reference to another article, which is Article 9, third paragraph of the same source, which defined what to intend with normal value, and it references to the average price charged at the same time and in the same place under conditions of free competition at the same marketing stage for goods or services of the same or similar kind. This definition was substituted by the newer version as introduced by Decree Law number 50 of 2017, which I previously mentioned. Now, I wouldn't repeat it, but essentially it's a clear reference to the arm's length price as contained by Article 9 of the OECD model. Okay, we can move on. Thank you. And now we determined the framework. I would now focus on the application of the arm's length principle. As my French colleagues anticipated, there are five categories, five methods which can be used to compare and determine the arm's length price. But in order to actually determine if an operation and a controlled operation and uncontrolled transactions are actually comparable, we have to look at, we need some comparability factors. The OECD guidelines come to help because they provide a series of mainly five factors which could be useful, relevant to our comparison. These are the characteristic of the goods or the services, the functional analysis of the transaction, the contractual terms, the economic circumstances, and the business strategies adopted by the enterprise and the company. Again, there are two groups of methods. The first group is the group of traditional methods. It was already anticipated, so I will just focus on the first method, which is the CAP method, or comparable uncontrolled price method. For the Italian legislation, this is the preferred method to use, as it's the most reliable. Of course, it's not always possible to adopt this method, because not always we don't always have comparability factors, those I just mentioned. But to focus mainly on the application of this method, I would say that it consists of a comparison between two transactions, controlled transaction and uncontrolled transactions. If the price if there is any difference between the prices of the two transactions, this may indicate that the commercial and financial relations between the two associated enterprises are not at arm's length. So the principle outlined by Article 9 has not been respected. And so by applying this method, we would have to substitute the price of the uncontrolled transaction for the price in the controlled transaction. Okay. very briefly, because I don't really have too much time, other methods include the resale price net, the cost plus method, transactional net margin method, and transactional profit split. In Italy, the second most used when the cap method is not available, of course, is the transactional net margin method. The legislative decree number 50 of 2017, I previously mentioned, also contains, introduced in our legislation, in our legal system, a series of additional rules which can be used to determine, to help both the taxpayer on the choice of the method and the tax authorities in their control activity. We have, it's worth mentioning, the best method rule, which consists, suggests that according to the most suitable method of the situation, we have to choose the cap method. It has to be preferred. And also that another probably interesting fact of the Italian legislation is that we need to choose the most suitable method for the case. Okay, moving on to granularity. Granularity is the main aspect, as anticipated, of transfer pricing. In Italy, in the context of Italian transfer pricing, granularity can be identified in a series of factors, mainly on the detailed and precise analysis which is requested both to the taxpayer and the administrative entity, tax authority, which is required to ensure that intergroup transactions actually align with the arm's length principle as outlined by OECD sources. This detailed and precise analysis requires express itself in a thorough examination of each transaction. So it's a single transaction, it operates on a single transaction basis. And this is the main difference from the Pillar 2 system, which instead operates on a jurisdictional basis and imposes a global tax, which is 15%. But more will be said about this by my colleagues. Also, I would like to outline the important, very small detail about, well, not so small, but important detail which which makes the transfer pricing system differ from the Pillar 2 one. The Pillar 2 system hasn't really resulted in an effective tax burden on Italian companies, as our legislation already provides for a 24% rate of IRES, so domestic corporate income tax, which is way higher than 15% prescribed by the Pillar 2. Though, however, there are, under a formal point of view, there are still some stringent compliance requests that have to be adopted by our companies, which will make, which if not followed, would result in penalties, which, based on Article 46 of the Directive 2022-2523, which is the one that introduces Pillar 2, would have to be effective, proportionate, and dissuasive. Okay, coming back to transfer pricing, in Italy, there is a possibility to be exempted from probable penalties if the enterprises adopt a series of documentation. We have a master file and a country file. Also, some language requirements are requested for both of these files. The master file represents a summary of the whole multinational enterprise, while the country file refers to the single company operating in Italy in this case. Yes. Again, what else? Yes, this is not mandatory documentation. It's optional, but it can be useful to benefit from the so-called penalty protection regime. Okay, so in case of an adjustment operated in the Italian, by the Italian tax authority, the enterprise wouldn't be asked to pay a fine. Essentially, that's what it is. Okay, finally, to conclude my speech, I would focus on the issue of the phenomenon of double taxation, which is on the next slide. Thank you. Very quickly, when we speak about double taxation, we refer to the eventuality that an upward adjustment operated by the Italian tax authority or by foreign state tax authorities, so for example, Germany and France, is not matched by a downward adjustment on the other side, so on the Italian side or the foreign state. This can result on an excessive burden on the companies, as they would be very logically requested to pay 2 times for the same income. In Italy, the problem was solved was addressed in different ways. It was already, I think, my colleagues already anticipated the mutual agreements procedure, or the APA maybe. In the originally, Italy, the previous version of Article 110, it was provided the possibility to obtain a downward adjustment on the Italian side, based on conventions, actually not really conventions, but what we call maps. If you could kindly move to the next slide, we can see, thank you very much, maps, so mutual agreement procedures, which would be provided for in international conventions, and would allow to find a solution, a common solution between the 2 different states. However, there is no real obligation currently to, in the context of maps, of course, to reach an agreement, but only an obligation to consult. So the 2 different state tax authorities have to consult, but they're not obliged to actually find a solution. In Article 31.4, which was again introduced by the same legislative decree we previously mentioned, so number 50 of 2017, the legislator introduced a list of the possible remedies. Again, we see mutual agreement procedures as contained in 2 examples, the main examples in the European Union at least. So the Brussels Convention, number 436 of 1990, also known as the European Arbitration Convention, and the EU Directive 2017-1852, also known as the European Union Dispute Resolution Directive. Again, a possibility comes from controls carried out in the context of international cooperation activities. So again, there needs to be a participation by the states. And finally, if there is a request by the taxpayer. And again, I didn't put it in the slide, but it's obvious, because without saying that, it needs to be a convention. There needs to be a convention for this request to be actually followed. Finally, I think it's worth mentioning the APAs. The Italian way of making APAs, which was introduced in 2015, and it's called Advanced Agreements for Enterprises with International Activities, as outlined by Article 31 there, introduced again in 2015. We see that this institution allows the Italian company to enter into an agreement, which consists of a real contract, with the tax authorities, agreeing and predetermining ex ante the conditions of the future transfer pricing phenomenon. Okay, and that's pretty much all. Thank you for your attention.